Hello, welcome back to A Taste of Justice. I'm Professor Angela Mae Kupenda at Mississippi College School of Law, but I give the name of my school only for identification purposes. All of the positions, interpretations, and arguments I make here are my own and are not to be ascribed to my school or to my students. Now, in our last video, we were talking about constitutional law. Remember, this series is for all of us, but it's also for my students. I teach constitutional law, and I also teach civil rights lawsuits. So we've done enough videos for con law for now. We have enough where we're talking about the major points that we will discuss further in class next week. So we're going to shift gears and look at the civil rights lawsuits course that I teach. And what I want to start with today with all of us in our quest for a taste of justice is to look at some of the tensions. You see, often we mistakenly think that if our constitutional rights are violated, that government is going to pay. We think that we will automatically be entitled to a recovery if constitutional rights are violated. And that is not the case. Section 1983, and you can look at the text of it, a summary of the text of it at the bottom of this video in the text portion, or you can Google it and read the full current version. But Section 1983, which was passed by Congress initially way back in the 1800s, has been interpreted by the courts. And that interpretation, in my view, is affected by various tensions. So in this first clip, I want us to talk about those tensions so you can think about where do you stand, okay? Now, let me ask you this question. For the first tension, do you think that the law should lead society, or do you think that society should lead the law? Okay, let me break that down. If you think the law, the legal system, should lead society, likely you're going to lean on the side of government. You're saying that government should create the laws, and therefore we have our best chance to act as an ordered country, an ordered democracy. But if you think that society should lead the laws, in other words, you're saying that through civil rights movements, we effectuate changes in the law. And those movements, those people who participate in those movements, therefore move the law in a better direction for all of us. If that is your view, then probably you're going to find yourself on the side of the plaintiff, the individual who's suing in many of these cases. Now, before I go on to tension 2, let me just tell you briefly what is just a summary of the text of the Civil Rights Statute, Section 1983, that you will hear a lot about in cases where there are individuals suing government officials. So the law provides, in part, every person who, acting under color of law, deprives another person of their constitutional rights shall be liable. Every person who is acting under the color of law, depriving another of their constitutional rights shall be liable. Now, that sounds rather simple, doesn't it? The application of it is not really that simple. According to the court, every person does not mean every person, and shall be liable does not always mean shall be liable, okay? Now, let's go to tension 2. What do you think is the best way to protect society? What do you think is the best way to protect society? Now, maybe you say, the best way to protect all of us is to give police officers and other governmental officials leeway to do their jobs. They're not going to be perfect, but no one is perfect. They're going to make mistakes. But if we step back and give them room to do their jobs, you may argue, we will protect society better. So is that your view? If that is your view, then likely you lean toward the position of the government in many of these cases. Or maybe your view is, when government or police officers make mistakes or cause deprivations of others' rights, they ought to pay, they ought to compensate those individuals. Now, we're not talking here about criminal liability. That would be a matter for a different course. We're talking about compensation, financial compensation for these injuries. So you may say, if government has to pay when they deprive constitutional rights, then government is going to function better and we're going to live in a better society because they don't want to pay. Now, if that is your view, then you're leaning on the side of the plaintiff. And likely you will find yourself leaning toward the plaintiff or the individuals whose rights have been denied. So I want you to think about that. Be honest with yourself. Think about it and think about where you stand today on those two tensions. And I say today, because usually when we go through this course, at some point, people start to shift from one side to the other. Now, before I tell you about the other tensions, I want to indirectly talk about those tensions by pitching a hypothetical to you. I'm going to pitch a couple of hypotheticals for you to think about. And then in the next clip, I'll tell you how the court actually ruled. So it's in the late 1960s. Monoroe and his family are at home. It's nighttime. They're in bed. And then all of a sudden, there are all of these Chicago police officers who break into Monroe's home unannounced. They force them from bed. They make them stand. They ransack the house. They arrest Monroe and hold him on open charges for 10 hours. They did not allow him to call anyone. They did not allow him to call a lawyer or anyone for help. And then after 10 hours of holding him at the police station, after all of this, they release him with no charges found. Now, Monroe says these persons, meaning the police officers, the defendants, were acting under color of law, and they deprived him of so many constitutional rights, he says, so they owe him. They shall be liable to him for damages. Now here comes the tensions. The police officers say, oh yes, we did all of that. What we did was unlawful, but we should not be liable. The police officers say, the law says that we're liable when we act under color of law. We were not acting under color of law. What we were doing was unlawful. It was not authorized by the law. Therefore, you don't win, Mr. Monroe, because we were behaving unlawfully. That means we were not acting under the color of law. I'm gonna let you think on that. Which argument do you believe to be more valid? The argument of Monroe or the argument of the Chicago police officers? Now let me give you another one to think about, same case. So in this same case, the police officer said, besides, Section 1983 was created by Congress pursuant to the 14th Amendment. That is correct. They said the 14th Amendment applied directly to the government, and that is correct. They say that 1983, one of the purposes was to act because the states were failing to act to protect the former slaves. That is correct. They say, therefore, Mr. Monroe, before you can recover here under this federal law, you've got to first go to the state and you have to see if the state will pay you. Then if the state doesn't pay you, then you come back and you file this federal lawsuit. What do you think about that? Do you think that that would be a good interpretation of 1983? What side do you lean on? Which side of the tension do you now embrace? Okay, let me give you another hypothetical. 3 things for you to think about before we go to the next clip. Well, I have to record it first. Okay, now, Bivens. Bivens is home in his New York apartment one morning, and all of a sudden, federal officers make an entrance in without a warrant. They search the house extensively. They also shackle Bivens in front of his family. When they get him down to the federal offices, to the Bureau of Narcotics, when they get him there, they subject him to what is called a visual strip search. A visual strip search. The officer, ultimately, of course, Bivens brings suit. The officers say, now wait a minute. Yes, we did those things, all of those things. But we're federal officers. 1983 was created pursuant to the 14th Amendment. They are correct. The 14th Amendment applies directly to the states. They say Congress didn't think to also apply it to federal officers. So therefore, Mr. Bivens, you would have to get Congress to change the law. And at that point, it would be too late to sue us. So therefore, Mr. Bivens, you cannot recover under 1983 because we are federal police officers, not state police officers. Now, what do you think about those hypotheticals? Commit yourself to a position in this analysis. These are not truly hypotheticals because they're based on actual cases. When we come back on the next clip, I'll tell you how the court did rule. For my students who are enrolled in my classes, you go and you read those cases. Then you come back and listen to the next clip. Again, this is a taste of justice. I want you to subscribe and sign up for notifications. We are seeking to learn more on our path to greater enlightenment and also on our path to justice. The Constitution says, we the people in order to establish justice. So please join me on the next clip with a taste of justice from Professor Angela Mae Kupenda. See you later. Bye. I gotta press this button. I'm down.